just want to do a brief introduction. I'm Brian Thiet. I'm with Equitable, Senior Vice President. I've been with the firm for a little bit over 14 years now. I've known Jeff for probably 10 or 12 of those years. This is my counterpart, Rodger Premeau. Rodger is really, from our firm standpoint, he's a subject matter expert. Rodger works internally with a lot of our advisors and planners and their clients, their legal teams, their accountants, through things like business succession planning. We're going to cover really two main things. We're going to spend the majority of the time covering planned business succession. So that's when everything goes right, and you want to sell, get out of the business, and it's planned. It's what we all hope for. We are going to take a little bit of time near the end to talk about unplanned business succession. There are various triggers that could potentially cause for an unplanned or a surprise business succession scenario. So we'll talk about that. After every sort of little piece, we will open it up for questions, as I said. If you do have any questions that you want to ask, but you don't want to ask it in the group here, Rodger and I will stick around for a little bit afterwards if you do want to ask us any individual questions from that standpoint. So standard disclosure that we have to give before we give any presentation like this. Rodger and I are not CPAs. We are not attorneys. We do not provide legal advice. We do not provide tax advice. But what we always say is we work with tax facts and legal facts. I mean, a lot of times it's pretty cut and dry what works, what doesn't work, what applies, what doesn't apply in the rules therein. So with that, Rodger, take it away.
Thank you. And because you're my color commentator. I'll do the play-by-play, you're my color commentator. So good afternoon, everybody. Thank you for attending. We have prepared remarks, but as you can see, we don't have prepared PowerPoints because I've been to a lot of these different seminars and that type of stuff, and I'm sure you've seen a lot of really good stuff. But this is all about you and the questions and concerns that you have. So understand that, like Brian said, I am not an attorney. I am not a CPA. I've consulted for lots of them when it comes to this side of things. Not everybody is a specialist in business succession planning. So my background, I've been in the industry for 17 years. I had one attorney point out to me that I've got more initials, more letters after my name than it's actually in my name, so I guess I win that one. Think of me as a big old financial nerd, all right? Yes, I know that's a four-letter word, but it's something that it fits. What Brian didn't tell you is in the Wisconsin offices, they call me Google. And there's a story behind that basically goes, somebody was at my door early on in my career, and they said, leave Rodger alone, he's got work to do. Why don't you just Google it? And the person at my door looked over and said, I just did, I asked Rodger. So, doesn't mean that I know everything, but I probably know where to find it. So, any presentation like this, you gotta start off with a little humor. I will warn you, my humor is very dry.
Very dry.
If it wasn't for bad humor, I would have no humor at all. And according to all of the public speaking books that I've seen, the only jokes that you can make in this environment are jokes about yourself. So, I've got no problem doing that whatsoever. And since I'm talking to golf course owners, I figured I'd start with a golf joke. By the way, all of you are very lovely people in my mind, because I make charitable contributions to your courses. What I mean by that is I pay greens fees, but I never use them. Normally at that point I just pick it up, bang my head in shame, and move on. Why is that? Well, because according to I'm a right-handed golfer, and I understand that if it goes left, it's a hook. If it goes right, it's a slice. For me, if it goes straight, it's a miracle. So thank you for laughing at that. So let's get into it. Let's talk. Brian talked about when it comes to business succession planning, there's two main types, planned and unplanned. For me, you should never have an unplanned business succession. It should always be planned. Now, the timing might be unanticipated, but you should have a plan in place. All right? So that's if you take anything away from this session, you gotta have a plan. All right? So, how do you get a plan? Well, let's first off start with what Brian talked about, the fun stuff. the anticipated, the decided upon. Some of you may have a calendar with the date marked off. This is the last date I own a golf course. By the way, is golf course like a boat where the 2 happiest days in your life are when you buy it and when you sell it? Never mind. Hypothetical question. So, when you have an anticipated transition, in other words, you are no longer going to be the head person, there's really 3 ways that you can unload a golf course, or any business for that matter. 1, you can sell it, and we'll get into some details behind that. 2, you can gift it, all right? Now, some of you, I see there's a couple of younger people in here. Maybe you're the successor owners or the heir apparents. So we'll talk about gifting it. And then the 3rd one is you can bequeath it, all right? Gifting and bequeathing come very similar, but they have slightly different connotations and tax ramifications. So let's start with selling it. In order to sell your golf course, what is the first thing that you need? You gotta have a buyer. That buyer can be another owner of the course. In other words, you're selling your share to the other owners. It could be somebody that's already in the golf course, whether it's your groundskeeper or your business manager, or it could be a family member, or it could be a third party. All of those have different ramifications. But at the end of the day, apparently it doesn't like my humor. At the end of the day, it's going to come down to valuation, all right? I've worked with a lot of business owners. And by the way, I don't use the phrase small business because I've never met an owner of a small business. For all of them, it was a big, important part of their life. So I've met a lot of business owners. Part of the problem with business owners is that they love their business. And in fact, they love their business. It's kind of like their kids, all right? And for those of you who remember Garrison Keillor up in Minnesota, everybody who has kids believes that they have a late woebegone child. Better than average, smarter than average, better than average. Everybody looks at their business in that way, and they have really accelerated ideas about what that business is worth. Unfortunately, that's not always reality, and if you're selling it to an internal buyer, you may not want to have that accelerated value, that really high value. Because once you have a buyer, whether it's internal or third party, the second thing that you need is you need funding. How are they going to pay for this thing? Now, if it's a third party, that's their problem, all right? They got to figure out how they come. It's just like buying a house. They got to figure out how they're going to pay for this, whether it's through loans or cash or whatever. If it's an internal buyer, whether that's your other business partners or family or an employee that works for you, they've got to have funding. So funding is kind of an interesting thing because as a seller, you have the opportunity to finance or you have the opportunity to do installment sales. So when you're looking to sell to somebody internally, you want valuation and you want funding. All right, that's your plan. You got to plan for how much is this thing going to be worth realistically, and how is whoever's going to buy it going to pay for it, whether that's through a note or whether that's through a seller agreement or an installment sale. Any questions on selling it to somebody inside the business? We're doing really good, Brian. They're speechless. Either that or I'm clear as mud. All right. If you're not going to sell it, that means you're going to continue to own it. And if you continue to own it, at eventually some point, I hate to say it, Mother Nature hasn't lost yet, nobody gets out alive. So if you're going to continue to own it, at some point, your interests are going to be ended up bequeathed to somebody else. Now that could happen through a trust, that could happen through a will. By the way, if you're a business owner, I highly recommend trusts, not wills, for a variety of reasons too detailed to get into in this conversation. So with a trust, that trust can continue to own the business and the beneficiaries, or the trust just distributes it out. If you die with your business in your estate, it affects estate taxes. or as the media likes to call it, death taxes. As long as you are below, well, as of today, as long as you're below 11.5 million, not a big deal. Probably by the start of next year, definitely by the start of 2026, you got to be below 5.5 million. And it's inflation adjusted, but if you're not below that number, you've got a business partner that you don't necessarily know about. And that business partner is the IRS. And when you pass away, your business partner is going to demand 40 cents for every dollar of value that's above that limit. It's called the estate tax. Right now it's at 40%. Where it'll be tomorrow, I don't know, ask a politician. I just deal with the facts as they are today. Talk to me in 3 months and I'll give you the new information. That estate tax is kind of like being pregnant. It's due 9 months after you pass away. All right? And believe me, you don't stiff the IRS. Interest rates, penalties, all kinds of bad, nasty stuff. Now the good news is that the IRS is willing to defer those payments over time. However, you have to state your business as an interest in order to get that deferral. And oh yeah, they do charge you interest and that type of stuff as well. And they'll give you 10 years, assuming the business is over 50% of your assets. For people who don't want to gift or don't want to bequeath their business, which by the way, the benefit of bequeathing it is that whoever inherits it, whether it's by a will or by a trust, they get a step up in basis, which means that when or if they go to sell that business, they don't have to pay capital gains tax. And if you've got any deductions for depreciation, so if you've got any embedded depreciation, that gets wiped out when you die as well. So you don't have to worry about capital gains or depreciation recapture. Well, you're dead. Your beneficiaries, people that get it after you, they don't have to worry about it. The problem with that is that since you don't know when you're going to die, you don't know how much that business is going to be worth when you pass away. So you got to do a little bit of projecting. I project a lot. Nobody ever believes me, but trust me, in this, you all think I'm a fraud. Another bad joke. So, you may want to decide that you're going to gift parts of the business. And again, you don't gift to third parties. You gift to family or employees. If you're gifting to employees, it's not a gift, it's compensation, so you gotta do payroll taxes and all of that other happy stuff. But if you gift to somebody, another family member, they get what's known as carryover basis. So they don't get the depreciation wiped away, they don't get the capital gains wiped away. It's not a big deal if they're not gonna sell it. If they're gonna own it until they die, that's not a big deal. If they think that they're gonna sell it, that can be a big deal. The problem with gifting is that you're still subject to those estate tax rules. Now the good news is there's discounts and there's a variety of different things that you can do, but you're still subject to those gifting rules. The other problem with gifting, and if you've got multiple business owners, that may be a problem in and of itself, but the other problem with gifting is that, actually, I keep saying problem and it's not a problem, this is the benefit. This is the benefit to gifting, I apologize. Benefit to gifting is that all of that future growth is the recipient's problem, not your problem. So there's really a balancing act. If you want to keep the business in the family, there's a balancing act between gifting and bequeathing. Where that act is for you completely depends. And again, if you're below 11.5 million today, 11.7 if we're going to be precise, or if you're below 5.6 at some point in the future, neither one of these is a big deal. You can gift all of it, or you can bequeath all of it. It doesn't really matter. It's only when you get above these limits that you really have to take these concepts into consideration. And again, this should be planned, all right? This should be in consultation. Will Rodgers famously said, estate planning is no big deal. Just go see an attorney before you die. Well, that might work for the average American, but that doesn't work for a business owner. All right? Since we don't know when we're going to die, go see an attorney, introduce them to your CPA, and get a strategy put in place. All right? Sooner is way better than later. I've dealt with some situations where there was no plan put in place and somebody passed away, and it was not pretty. All right? Fortunately, the business didn't sink, but there were a couple of instances where it was close. So make sure that you do this planning up front. Any questions on that? Yes?
When you gift, so like a husband and wife could each gift an amount to their son or daughter?
Yes. So the current limit is $15,000 per year.
15, that's what.
Yep, $15,000. So a husband and wife can gift to $30,000 to their son or daughter. Now, if that son and daughter is married and that marriage is stable, a husband and wife can gift $60,000 to a child and their spouse. But it does become a joint ownership at that point. So if there's a divorce, it gets really ugly. Another question?
Yeah. How do you put an evaluation on the assets?
Well, that is the big question whenever you're gifting, because you have to get a valuation done. Now, this is why I'm not an attorney and why I'm not a CPA. You can do whatever you want until the IRS comes knocking. Typically, it's through an audit or a letter of investigation. So, if that happens, you better have a valuation that will stand up to an IRS audit. Those are not inexpensive. We're typically looking in somewhere in the neighborhood of $10,000 to $15,000. And by the way, if you're going to get a valuation done, have your attorney order the valuation. Why do I say that? Because if an attorney orders the valuation, it's attorney-client privilege. If you order the valuation, it's yours, which means when the IRS comes knocking, you have to turn that over. Now, why is that a big deal? Some people don't like the first valuation that they get. It's too high, or it's higher than they want it to be. So they hire another valuation specialist who gives them a lower, and that's the one that they use. Well, if you're under an audit situation, IRS says, why didn't you use the higher one? Because trust me, the IRS wants you to use the higher one. That gets them more of their 40 cents per dollar. So you have to hire a valuation specialist. Now, if it's not that big of a deal, have your CPA make an estimate of what the value is. And remember that when you're valuing a business, it's not necessarily the value of the land, the improvements, that type of stuff. The IRS defines value as what a willing seller and a willing buyer with full knowledge of the facts and neither one under compulsion to sell or buy would agree upon a value. All right? So basically what it says is that it's a negotiation. When it comes to a business, there's a lot of different factors depending on who that buyer is and depending on the motivation of that seller. The other thing is, especially when you're gifting, if you're gifting an interest in the business, it's worth less than whatever fraction of the business it is. So let's say that your business is worth $4 million. All right? Somebody came up and offered you $4 million, you take it in a heartbeat, your business is worth $4 million. You want to gift 1% of that business to your child. Well, that 1% is not $40,000. Because an external third-party buyer probably wouldn't pay $40,000 for 1% of that business. Number one, they have no say in how the business is run. Number two, they probably can't unload that $40,000 or that 1% of that business interest to anybody else. So they're not going to pay $40,000. They might only pay $30,000 or $25,000. So when you're gifting, you want to make sure that you're valuing what you're actually gifting as opposed to a proportion of the value of the business. That make sense?
I would say it's fair to assume that amount is usually lower than just the fractional, simple math calculation.
Yeah, especially when you're dealing with very small percentages.
Yep.
The smaller the percentage, the higher the discount, right? Because if I've got 49% of a business, well, that's not too much before I get control. But if I've got 1 or 5 or 10, that's a pretty steep discount. Does that help?
Well, sort of, but if you're gifting, you're only gonna, excuse me, if you're gifting, you're only gonna give a certain percentage of the value each year to that person. So how does that play into it? Because now you are dealing in.
Well, if you're going to do it serially like that, you're going to have to get valuations each and every year. What I would recommend, though, is that the $15,000 per person limit is what you can gift without notifying the IRS. If you go above that $15,000, you have to fill out what's known as a gift tax return, which is basically a notification to the IRS that you've gifted above that $15,000 to somebody. But to the extent that you stay under, this year, if you stay under $11.7 million, you're not going to have to give a dime to the IRS. You got to fill out the form, but you don't have to pay a dime in taxes because you're using up your lifetime exclusion. The exclusion when you pass away and the exclusion when you gift is unified. So it doesn't matter when you use it. You can use it while you're alive, or you can use it after you pass away. So in your scenario, let's say that your target is you want to get 15% to your kids. Rather than doing 1% for the next 15 years, if you've got the limits and the ability to do it, I would just give all 15% this year so that you're only paying for one valuation. Now, if you eventually want to get them where they're 55 or 60% owners, then you might have to do valuations for, say, 4 years and do it over that time. Or, if you've got room to do it, just do the 60% now. The other thing is depending on how your businesses are set up, a lot of business owners are like, well, I can only give them 49%. When it comes to business entities, there's ownership and then there's control. If you're set up as an S corporation, you can't have different dividend-paying shares, but you can have voting shares and non-voting shares. So I've got S corporations where 99% of the stock is non-voting. 1% is voting, and by the way, voting means control. So the business owner, the patriarch, if you will, or the matriarch, if you will, gives away the other 99%, and they keep the 1%. So they have all of the control, but all of the dividends go to wherever. And by the way, when you have full control, you also nominate the board. And since the board sets executive benefits and salaries, they're pretty okay. Yes?
So I guess you can both gift and bequeath.
Yes.
And excuse me, are there different, does it affect you still have to have an evaluation every year.
Every year that you're going to gift, certainly.
Every year you're going to gift. And then when you finally bequeath, are there more tax implications to that?
Well, there's potential tax applications, and you would need a valuation of whatever interest is remaining under your control when you pass away. So you would have to have that final valuation. And again, if you're below 5.5, or today's number is 11.7, none of this really matters because no estate tax consequences are there. You still got to report it to the IRS, but they don't get a pound of flesh. All right? They don't get their 40 cents because you're below the exclusion limit.
All right, not to get over complicated with this, but let's jump ahead to, what's it, 2026?
Yep.
Okay, 2026, and your entire estate is worth more than 5.5.
Yep.
Only the golf course goes to one person. The balance of the assets go to another child. Doesn't want anything to do with the golf course. Does the person that inherits the golf course, do they get hit with a tax because the total estate is more than 5.5?
Neither one of your beneficiaries gets hit with the tax. Your estate gets hit with the tax. So your estate is responsible for paying that 40 cents to the government. Now, it doesn't matter who gets what. So let's say that you got 6.5 million. That additional $1 million of assets, whether it's in retirement accounts, investable stock, whatever, that's subject to that 40%. So $400,000 has to go to the IRS. Now in your scenario, we've got a problem because whoever inherits the golf course, that's not a liquid asset. Unless they're gonna mortgage the property to the tune of $200,000, there's really no money there that they can send. Now, maybe you've got a little bit in the bank account of the business to handle maintenance fees and that type of stuff. But the person that gets the other assets, assuming that they're liquid investments, well, where's the $400,000 gonna come from? So that's kind of the problem when you have a business that is going to one and not going to the other. And there's ways to work around it. There's ways to plan for it, but that is why it absolutely has to be planned so that you've thought about these different scenarios and you've got a strategy in place to handle it. Because what happened in a lot of cases with those unplanned transitions, it's exactly what you're talking about. One or two of the kids got the business and the other kids wanted nothing to do with it, so they got the quote unquote liquid assets. But those liquid assets are what was required to pay the estate tax, and they're fearfully cheated. Also, this kid or kids got $5 million of assets, and this kid only got one. So there's a fairness issue. And by the way, equal is not fair, not necessarily fair, and fair is not necessarily equal. Because maybe these kids have been involved in the golf course forever, and they've helped build it. So they, yes, they're getting a $5 million asset, but they helped build the last $2.5 million of value. Excellent question. Yes, in the back.
In that scenario, you could gift the golf course and then have the ones that aren't involved in the golf course, you could have that stated that they pay the estate tax out of the liquid assets, correct?
Correct. Now, again, what typically happens is we create a sinking fund, or we use life insurance, or we use something else to cover that tax bill. All right, so it's that way there's a separate pot of money that nobody's expecting to inherit that goes to satisfy the IRS. Question?
What was the scenario where you can recognize a step up in basis?
When you bequeath it.
You bequeath it.
It's got to be subject to estate tax in order to get that step up. If it's not subject to estate, and again, you don't have to pay estate tax. It's just got to be in your estate when you die. Then whoever inherits it gets a step up in basis. So that's pretty powerful. And if you want that to happen, then you really better plan. If a tax is going to be due, you better plan for how the tax is going to be handled. Great questions. Yes?
Yeah, 5.6 or whatever, that's, right now it's 11.7.
Yep.
Is that level gonna stay there as far as the 5.6, but the 11.7 might be moving?
The 5.6 is, and the 11.7 is inflation adjusted. Okay? So what happened is we used to have 5 million. Back in 2012, it was set at 5 million. And then in the Tax Cut and Jobs Act in 2017, they doubled it to 10 million inflation adjusted, which today stands at 11.7. And under the current proposals for the reconciliation bill, they're talking about cutting it back down to the 5 million that we had in 2012 inflation adjusted. And even if they do nothing there, the way that the Tax Cut and Jobs Act was set up is that it was set to revert back to 5 million in 2026 when all of the personal taxes sunsetted at the end of 2025. So,
Clear as mud, right?
I was gonna say, my background actually is mechanical engineering, and everybody said, why did you go from mechanical engineering to this? And the answer is this is way more fun. Mechanical engineering really hasn't changed since the apple hit Newton. It's just applied physics and mathematics. This is applied mathematics, but the rules change all the time, so it's like spaghetti, yay! Keeps a nerd like me happy.
The biggest thing that, just to maybe add a little bit more clarity is, If nothing changes, it'll revert back down to the 5 million figure in 2026. Yet right now in Washington, not to get all political, there's a lot of talk about possibly having the number revert from 11.7 million down to 5 million. Could happen in the next couple of months as Washington works out the reconciliation bill and all of that kind of stuff. So that it could speed up the time frame for that reduction back down to about 5 million. And who knows what actually ends up happening.
Before 2026, you could do the gifting to the 11.7 if nothing changes.
If nothing changes, but
You want to.
Yeah, you basically have a 2-month window, 2-month and 1 week window. If you've got 11.7 million that you can dispose of, you've got a 2-month window where this is the current law. By all means, gift it. Because if you gift 3 million, when it goes back down to 5 million, you only have 2 million left. So it's only the amount of 5 million that really benefits you. And trust me, every estate planning attorney and every CPA is going nuts right now because they've been working on this for the last 9 months since they talked about it. And I can't get a client in edgewise.
yeah, there may be a very small window of opportunity, basically in November and December of this year,
Yeah.
if the reconciliation bill goes through with those anticipated estate tax changes.
So any other questions around anticipated transition? Because I do want to spend about 5 minutes talking about unanticipated transitions. And what exactly is an unanticipated transition? Well, it could be an unexpected death. All right? That's what everybody thinks of. Well, what if I pass away before I expect to? Unfortunately, there's 4 other triggers that could cause an unanticipated transition.
Excuse me,
Yes.
one other question. If you're going back to the gifting thing.
Yep.
What kind of documentation do you have to have? Because you're not physically giving them anything. I mean, you're.
Well, actually, you are, depending on how your business is set up. If you're an LLC, you're giving them interest in the LLC. If you're an S corporation, you're giving them shares in the S corp. If you're a partnership, you're making them a partner. So they're getting some sort of legal documentation. Now, if you're just a sole proprietor, you would have to shift from a sole proprietor into a partnership in order to give them some interest.
But you have to have, don't you, I guess my question is, what kind of documentation do you have to gift that? I mean, to show that you've done it.
Every business has a books and records, so you just notate in that record that X% of interest or X number of shares was transferred to XYZ, and then for your documentation, you got that valuation to talk about what it was worth that you actually transferred. And if you're a corporation, there tends to be a corporate resolution talking about that gift. Or your attorney just drafts a memo of understanding that you slide into your legal documents indicating that it was transferred. So you're not giving them a physical thing other than, well, these days I don't even see paper go around, they just get a notation in a book. So they get a digital interest, I guess. Although you could make a nice certificate suitable for bringing. Maybe like a Packer share or a Disney share. Great question. All right, let's talk about unanticipated. So premature death, that's an unanticipated transfer. Based on the audience, I don't think I have to worry about the second one. Divorce, all right? Wisconsin's a community property, marital property state. So if you become divorced, 50%, 50%, well, actually you get a third, and the attorneys get a third. But, so that could be an unanticipated transition. Disability, not such a big deal when you're dealing with a golf course, although it could be a big deal if you're also the head groundskeeper. What happens to the business if you become disabled? The other one is, and this is typically only common when you have multiple owners, but involuntary termination from the business. What do I mean by that? One of the owners was embezzling from the firm, you fired him, and now you want his shares to come back to you. Actually, there's a lot of legal precedents where an owner was embezzling from the business, and because it wasn't set up in a plan, they still get to keep ownership, and they're still eligible for their dividends unless the other partner or partners buys them out. It's really messy. I don't recommend it. And then the other one is just voluntary termination. You decide, you know what, I've had enough, and the other partners may want to buy you out, as opposed to go into business with one of your kids. So the document that you're looking for is what's known as a buy-sell agreement. An attorney can help you draft one, and a buy-sell agreement basically says that in the event that one of these triggers occurs, what happens? In other words, do I sell? Do the other partners have to buy me out? Does the business have to buy me out? And whenever you have a buy-sell document, it's a legal contract. So you better have a funding mechanism behind it. Some funding mechanisms are, again, sinking fund, life insurance for death or other circumstances. There's actually such a thing as disability buyout insurance that you can get to cover the event of a disability. And otherwise it's just specified financing inside of the document. 10 years at whatever prevailing interest rate is, that type of thing. The one thing that I will say is that if you have a buy-sell document, the classic error is to get it drafted, put it in a drawer, and ignore it. Not a good idea. Because that buy-sell document will typically define how the business is to be valued, what the financing mechanism is. Now, the financing mechanism, when that document was drafted, might be appropriate for what the value of the business was at the time that it was drafted. But when it's triggered, it might be completely inappropriate. I had a business that they drafted the buy-sell business when the business was worth $1 million. Now the business is worth $7 million, and the funding mechanism was a loan paid off in 2 years. Yeah, that didn't work because, quite frankly, it would take all of the cash flow from that business. Basically, it would take all the cash flow from 3 years of the business just to cover 1 year loan payment. So, good thing we saw it. We got it redrafted, turned it into a 15-year repayment, and good to go. So, if you have a document, don't ignore it. Make sure it's up to date. And if you're not going to keep it up to date, as much as it pains me to say this, don't draft it. You're better off taking your chances with an unplanned, unanticipated, than having a plan that's out of date. Because again, it's legally enforceable. So with that, that is my prepared comments. I will definitely open it up for questions. And Brian, color commentary.
No, good job, Rodger. A lot of good questions from the group. Just the one thing, especially when you start getting to the buy-sell funding, buy-sell agreements and documents and things like that, is the business is an illiquid asset, and oftentimes what's needed if a trigger were to happen is some sort of liquidity, and that's always the challenge. When the statistics we've seen is 9 out of 10 businesses don't have a properly drafted and funded buy-sell agreement. The buy-sell was done 12 years ago when the business was worth $1 million, like Rodger said. Now it's worth $6 million. Something happens, one party's going to want the business valued at $1 million, the other party's going to want it valued at $6 million, and all that means is the attorneys get involved, and it gets very, very expensive to iron everything out. So definitely something that should be updated and reviewed on a periodic basis. Any other questions? I mean, that really covers what we wanted to go over in terms of spending the majority of the time on planned. Everything goes right, everything's good, and then just a little bit here at the end about unplanned. Any other questions? Any comments or topics we didn't cover that you would want us to?
Is there a better time of the year or a better time to decide that you want to sell?
That is very dependent upon your industry and that type of stuff. It's also dependent on if you're selling to internal or if you're selling to a third party. If it's internal, there's not really a better time of the year per se, other than when you've got the time to do it right. So you can get the valuation done, you can meet with the attorneys and the CPAs, and you can do all of that. If it's a third party, if the money's right, the timing's right. So, you know, that's kind of how it tends to go. But I would say, you know, no, there's not really a better time of the year to do it. Where historically what I see is that everybody does it in December so they can hurry up and get it done this year. The attorneys and the CPAs want to enjoy their holidays as well. So probably avoid April 15th and thereabouts, avoid October 15th and thereabouts, and avoid 12/31 and thereabouts. Anything else? And again, Brian and I will be around after to handle any questions or whatever, because again, your businesses are unique to you and they share a lot in common, but your financial circumstances are private. It's funny because when I got into this industry, there were 3 things that you couldn't talk about. You couldn't talk about sex, you couldn't talk about politics, you couldn't talk about religion, and you couldn't talk about money. Now, about the only thing that you can't talk about in public, unless you're, you know, really, is money. Everything else, people talk about it all the time. So, we still have very rude conversations.
Our contact information, the packets that you received, our contact information is in there. So if you do have any questions, you do want to have a private conversation, you don't want to ask, in a group setting like this, by all means, Rodger and I are happy to have any of those conversations with you. Jeff did.
Perfect, thank you, Jeff.
So,
They'll be around here for a while.
yeah, and we also have, for anybody who's interested, we do have a packet here that just talks about some of the stuff that we talked about here, okay? I think it's 10 or 11 pages long, and it just goes over a lot of the stuff that we talked about, funding, valuation, things like that. So whoever wants a copy, you can swing up and grab one. So thank you again for the time. Really, really appreciate it.